On behalf of Financial Poise, my name is John Levitsky. I'm going to serve as the moderator today, and it's my pleasure to host this program on common issues and strategies in business breakups. This is the first in our program in 2026 in the Complex Financial Litigation series. I'm going to have a chat with our speakers, Megan Beckwar, Harold Israel, and Max Stein today that we hope you will find interesting and informative. Before we begin our program, we'll go for about 60 minutes. I want to mention a few housekeeping items. First, today's program is co-sponsored by Financial Poise, which provides education for attorneys, accountants, business owners, executives, and investors, and also co-sponsored by the National Law Review. It's a website and publication that offers analysis on a wide range of legal and business topics. And as you noticed, I'm flipping through slides. So in addition to the introductory material and disclaimer, there's a real slide deck of materials here for you that we encourage you to leaf through as it's convenient for you. You're also welcome to print it out and take notes. We won't be flipping through the slides directly in the program, but it may be helpful for you to refer to these materials. A quick disclaimer. We're here to provide open and frank discussion, but we aren't giving advice regarding anything in particular. So if you'd like specific advice, consult with your own advisor. And of course, all of us on the panel would welcome your questions directly. Feel free to email us after the program if you'd like to contact us. Our panelists today, I'd mentioned Megan Beckwar. Megan is an experienced business valuation and forensic accountant practitioner based in Philadelphia. She has her own firm, Dispute Economics LLC. We also have Max Stein. Max is a highly experienced attorney, a wide range of experience in state and federal courts. He's litigated numerous types of situations, and he's a partner at Maxon, Mago, and McCauley here in Chicago. I'm John Levitsky. I'm a partner in the Forensic Accounting and Commercial Damages Group. I do a lot of business valuation expert work as well. I'm with HKA. And in addition, we have attorney Harold Israel. He's also a highly experienced attorney. He's with the firm of Levenfeld and Pearlstein here in Chicago. He focuses primarily on debtors, fiduciaries, asset purchasers, secured lenders, landlords, creditors, and official creditor committees and workouts and reorganizations. So we thank our speakers again. And today we're going to talk about the common issues and strategies in business breakups. And you probably can tell by the range of experience of the individuals on the panel today that there's a variety not only of issues that arise in potential breakups or actual breakups, but there's a variety of expertise that may be helpful depending on the particular situation. If you'd like to know more about the other episodes in this series, they're listed in the slides. And I'll just leaf through real quickly here to give you a sense. There's quite a bit in the slide deck that you may find very helpful to review either during, again, or after today's program. So I'm planning on leaving the title slide up for reference, and then we're going to speak with our individual panelists. So over the next hour, we'll talk with Max, Harold, and Megan. And Max, we'll start with you. So today's topic, Max, is common issues and strategies in business breakups. So let's start from the beginning. What do we mean by a breakup? Or are we talking about a business divorce? Or are they one and the same thing? So Max, I think your sound is off.
Thank you very much. Sorry, I was just saying how I suppose sounding very much like a lawyer, the answer to your question depends on the legalities. It might be just a breakup if you don't have a formal document, and it might be a business divorce if you've gone through a wedding ceremony by having an LLC or other kind of business agreement. But basically what we are talking about is the kind of breakup that oftentimes is every bit as, if not more than, every bit as emotional and involved as an actual relationship breakup or divorce. What we're talking about here is people who previously were able to work together and make a livelihood together, who, for whatever reason, and there are many reasons, end up falling out of being able to do business together and end up needing to break up. Um, I really do actually refer to these kinds of disputes as business divorces because I think it helps the people involved, especially my clients, to understand the nature of the dispute, that it is going to be at times every bit the emotional roller coaster that a real divorce in your personal life might be. And so it is one in which you have to deal with both business issues because there is a business that is at the heart of the dispute, but then also emotional issues. And oftentimes you end up having to do a bit of the kind of therapy work that you often see being done in other kinds of breakups and divorces. So it is all of those things. It begins with people who have previously been able to work together, but for whatever reason are no longer able to. And that can take any number of forms and come from any number of reasons.
Well, thank you, Max. Harold, at the outset, I mentioned you have a lot of experience dealing with essentially potentially troubled businesses in terms of their financial situation. So, what are some telltale signs of a failing business?
Well, thank you, John. One is obviously a slow pay. Vendor that always pays 30 days, all of a sudden it's day 45 and you're not getting payment. Non-responsive communication, no responses to emails, text, voicemails. For a company that's very active on social media, seeing a decreased social media presence. If you are asked to pay a lender instead of the company for your receivables, that is a surefire sign because that means the receivable has either been sold or what's known as factored. If you're reading about a large number of employees leaving, that is another sign. Also negative press and increased signs of customer dissatisfaction with the product.
And I would just add to that, particularly in the realm of business divorce, one of the telltale signs that I often see is when you've been dealing with one of the members of the business and all of a sudden you're asked to deal with a different member of the business. And that's often a sign that there's something going on behind the scenes that they're not necessarily wanting to tell you and frankly don't have to tell you, but it's certainly a sign that something's going on.
Yes.
So Max, why do business breakups occur?
As I've noted a few times, they actually occur for a whole bunch of different reasons, some of which are foreseeable at the beginning, and some of which really aren't foreseeable at the beginning. So they fall into a few different categories that we highlighted in the slides. But the most obvious and predictable ones are changes in the business. And those can be financial changes that come about because of retirement, because of success, that come about because of changes in the industry. All of these kinds of things can lead to financial pressures that can create changes in the dynamics of the business. Those changes can be as bottom line and as obvious as bankruptcy and lost revenues and therefore lost profits, but it can also take the form of increased profits and changing in the percentage of where the profits are coming from in a business. So that in a business where originally let's say there were three members and each of the three owners was equally contributing to the success of the business, and then there's a change in the marketplace, and one of the three owners is now contributing more to the success of the business than the other two, that can create tension and lead to problems. There can also be external factors that have nothing to do with the business itself. It could be generation changing, where one of the owners of the business wants to hand the business down to a kid, a spouse, whomever, and the other members of the business aren't on board with that, or that creates problems. It can also be things as tragic as the untimely and sudden death of one of the owners unexpectedly. And then, of course, there can be things like inattentiveness of members. There can be things like ill action or malfeasance by some of the members, including fraud, those kinds of things. And then there's also yet more external factors like changes in regulatory environments, including most recently, we've seen things like tariffs and those kinds of things, interest rates. All of these kinds of things can on their own or in combination create the sort of perfect storm that creates issues and resentments within the business. And then even if those resentments and issues at first seem small, they can linger, they can fester. And even if they might have been a misunderstanding at the front end, by the time you get to the back end, they can create the issues that result in the business needing to be broken up and the owners at each other's proverbial and sometimes literal throats.
Yep. And building on what Max said, failure to adapt to new technology. We saw this last time around when companies did not adapt to internet profiles, and the ones that didn't often didn't survive. Right now, I think what you're going to see is those that fail to adapt to AI are also going to have trouble competing in the future. And of course, if you have a high customer concentration, if that one customer leaves, that can be the death spiral for the business.
Well, thank you. It sounds like, Harold, that some of the reasons that business breakups occur might be related to owners that haven't done timely planning. So what are some of the reasons that timely planning may not be occurring?
Well, I think once a business gets running, they often start with like a business plan, right? They're trying to attract investors, trying to get lenders to lend them money. And then the business starts going and they forget to update the projections, or they don't always assess their place in the market. Are there new entrants? Are there new cost saving techniques that they have not adopted? And so they sometimes get left behind, even though they're making the same product and doing the same thing. Other people have caught up to them, or they're just too busy that they forget to go back to the basics. And that is often a reason for business decline through no fault of management. It just kind of happens. And something we often suggest is to at least annually have a meeting where the only agenda item is where we are in the market, looking at projections, looking at competitors, and what we could be doing differently than we were doing next year than compared to what we were doing in the past few years.
And I would add along those lines, one of the most common things that I see is the fact that when everybody is getting along and agreeing on things, it's very easy to gloss over the small disputes, and you gloss over them. You don't paper them. You come to a resolution that you informally agree on and that is fine for now, while everybody is getting along and while the business is good. But come 2 years ago, when things have changed and not everybody's getting along or the business isn't as good, suddenly those kinds of things that you didn't actually address when everybody was getting along become the flashpoint. And along the lines of good corporate hygiene, if you address it when you're all getting along, you're much more likely to be able to handle those kinds of things when the issue pops up later down the road, when there's perhaps tension points and points of friction in the business.
That's absolutely right. The importance of having a good operating agreement or good bylaws cannot be understated, not only at the beginning when everybody is getting along, but also it sure helps to manage if things don't go so well, because you have your agreements in the piece of paper, which is a great base point. People often don't do it because they're going into business with their family or their best friends, and they think everything's going to be wonderful until it's not. All of us on this panel have seen instances where people who started out as best friends are no longer speaking because of what has gone on in the business, and they don't have a plan to work it out. Cost is often given as a factor, but I think all of us would advise a few dollars in the beginning can save you a whole lot more dollars at the end.
A
Absolutely.
whole lot more at the end.
Harold, are there some other examples of things like changes in the regulatory environment that might be unforeseen or unplanned events that may precipitate a business breakup?
Absolutely. Like Max and I were both talking about a little earlier, there could be a change in the environment that puts your company out of business. I mean, we see it right now with solar power, right? And this is not political, but the last administration had one view on solar power. This administration has a different view on solar power. If you're in the solar power industry, your prospects have changed dramatically. But it's not just the government, right? The old story is Amazon, right? When Amazon gets into a new marketplace, that changes the world for which you operate. It puts a lot of small businesses in a place where they did not foresee. Are numerous, but right now the grocery store industry, right? We're seeing, Amazon insert more and more influence on the Whole Foods entity, and whenever there is a change, whether it's tariffs, government policy, taxes, interest rates, it often has a disproportionate impact on certain businesses. And so you need to have the ability to adjust when those changes take place.
Well, thank you. Megan, we heard about how good planning by a company can be helpful in avoiding or mitigating, or at least minimizing the disruptive effects of a potential business breakup. And we heard about the importance of operating agreements. So, Megan, are there sometimes buy-sell provisions in operating agreements?
Yeah, and sometimes they come in the form of a separate agreement altogether, but it's an important factor that gets addressed at the outset, where the parties determine what is going to happen should changes in the ownership of the business take place. Like all of these different scenarios that Harold was speaking about, if somebody does pass away suddenly and their shares get left to a spouse, do we want the spouse to then be a business partner, or do we want the provision to state that there's going to be specific set of calculations that are done to value the shares and get that individual paid so that they don't end up, it could even end up controlling the business depending on the ownership of the shareholder who departed. It could also happen in a divorce. If one of the shareholders gets divorced, they could have a former spouse that's given a share of their ownership interest. And again, you may or may not want to be in business with that individual. So this is kind of just planning up front for some of the things that can be foreseen a little bit more. In times when you cannot foresee some of these other scenarios, there's often a calculation that'll be provided in the buy-sell agreement that will determine how the business itself will be valued. And sometimes that's a really simplistic formula. And sometimes it goes so far as to say, this is the specific analyst we want, and they're going to employ these methods. And that way we all are in agreement about how this thing is getting valued later on.
Harold, sometimes we hear this term squeeze out. What is a squeeze out? And is that something to avoid?
Well, first to define it, it's basically a freeze out, creeping dilution, cash outs, coerced buybacks, removal from management, or other similar tactics where one group of shareholders or members get in effect eliminated from decision-making policies. And consistent kind of with what I think all three of us have now said, the best time to protect yourself from that is at the very beginning, in the operating agreement and in any equity type documents. Actually got a call yesterday from a disgruntled investor in a startup company, whose best friend, of course, was his business partner and started the business, and now is acting, at least in his view, very inappropriately, and he wants to know his rights. And unfortunately, he did not negotiate a very good operating agreement, so his rights are very limited. But what can you do? First is to make sure that there's supermajority voting for certain fundamental actions like a merger, charter amendments, asset sales, certain debt recapitalizations. So the majority can't control, you need a supermajority. Another is to have class or series votings for changes that disproportionately impact a class. Cumulative voting for board seats, entitlements tied to ownership thresholds, staggered board terms, having financial reporting on a regular basis, inspection rights, board observer rights, basically taking action so you are actively keeping up with the business and have a say as to what is going on, as opposed to just letting the majority rule the day. Other examples include anti-dilution protections, most favored nations in any side letters to make sure you can't get diluted, balanced tag-along, drag-along, and buy-sell mechanics that are going on. Basic key is at the very beginning to set up the governance documents and the economic documents to block coercive maneuvering. Because if you wait or if there's nothing there, you are at the kind of beck and, I won't say call, lack of call of the majority shareholder.
So Max, if I'm a shareholder and I'm upset and I have a grievance, can I just say, hey, I want arbitration, and an arbitrator takes jurisdiction of the dispute, or is there a lot more to it than that?
Here again, it's going to depend on how much planning everybody did at the front end. So arbitration provisions are often included in operating agreements, like the good ones that Harold was referring to earlier. Oftentimes those provisions, they may be mediation provisions. They may be a form of sort of binding mediation. I've actually seen in some operating agreements where the parties agree at the front end that if we get into a dispute, we will go and talk to this person and leave it with that person. And that person's decision will be binding on us all. It's kind of like an arbitration, but it sounds almost more like a mediation. And then it can even be a formal arbitration, depending on what the agreement provides for. If you have a well-documented plan, that plan should govern and should be the way that any disputes are resolved. For arbitration, it can be take a few different forms, including with whom you're going to arbitrate, how much process you're going to have in that arbitration. You can agree at the front end to a truncated arbitration in which, for instance, only written statements are presented, or only a few witnesses are presented, or you can agree to a full-blown trial like you would have in regular quote-unquote litigation, or regular quote-unquote regular litigation, but that you're going to do it in the form of a private arbitrated proceeding. All of these are options that you should talk through at the front end and get that agreement at the front end when everybody is happy and willing to agree to things. And you might even go so far as to agree on one of the more radical approaches to these kinds of disputes is what's called baseball arbitration, where the arbitrator has to pick between the two numbers that the numbers that the parties involved in the dispute submit. And the idea of that kind of an arbitration is it theoretically should force the parties to be reasonable, because if you start way too far at the extremes and hope to just get to a middle. In baseball arbitration, the arbitrator has to pick one end or the other end. Can't pick any numbers in between. And if your number is the outlier, that arbitrator is going to decide on the one that might not be as fair to you as you could have been, but is much closer to fair than your number. So there are a lot of things that you need to consider. Harold's client who called him yesterday didn't do a great job at the front end, perhaps, of getting a good agreement, but he did do the right thing in calling his lawyer early on and consulting with the lawyer to figure out what his options were and where things might be headed.
Well, Max, is a follow-up. If an agreement does contain some arbitration dispute resolution provisions, is it possible that sometimes the agreement has different paths depending on the nature of the dispute? Could it be, for example, if it's an accounting or valuation issue, it goes to a certain type of arbitration process, but if it's a contract dispute, maybe it goes to another type of arbitration process, and maybe there's even a third realm. Say if it's a fraud, maybe it goes to litigation or it goes to a different type of arbitration process.
Certainly, any of those kinds of things are the kinds of things that you can discuss at the front end. And in particular, I think you're highlighting the idea of an agreement about valuation and how that's going to be handled is a smart one, because oftentimes you will find that at the beginning, people involved in a business are much more likely to agree on how to value their business than they are down the road when they know how they value it will impact them. There's a political philosopher named John Rawls who has this concept of the veil of ignorance. And the idea is what should be fair is what is fair if you don't know where you're going to be in the dispute or in the society at the time. And that's really what the idea of agreeing on a valuation would be, because you don't know when you agree on it how it's going to impact you down the line. And so you want to do whatever would be the fairest, regardless of which position you're going to be in when the dispute comes.
Well, thank you. Max, we have some other things we'd like to ask you about. We're going to turn back to Harold and Megan in a few minutes, but we're talking a lot about breakups. And is this most commonly involving private companies that are closely held? And are some of these issues more challenging or more magnified because they are involving private, closely held companies?
Oh, without a doubt. This is oftentimes, like Harold was saying earlier, a dispute between people who were once best friends or brothers, or there are some sort of notable cases under Illinois case law where two brothers were in business, one dies, and then you end up seeing a dispute between the surviving brother and the deceased brother's widow, where the surviving brother perhaps wasn't acting as perhaps the documents might have said that they were going to act with regard to the value of the business for the widow. So these are definitely things that can create lots of tension, and the nature of the business will definitely add to that. One of the stories that I tell about how to avoid this kind of thing, in Chicago, there used to be a store called Polk Brothers, which is where half of Chicago bought their appliances, their furniture, their carpeting, all kinds of things. It was literally a family business created and run by the Polk brothers. They all agreed that none of them were going to transfer their ownership of the stores from themselves to their spouses or to their children. Instead, they agreed at the beginning that when they died or wanted to retire, their ownership on the stores would be transferred to a foundation. That ironclad agreement held, and as a result, as the Polk brothers stores went out of business in part to all of the market pressures that we were talking about and the market change that we were talking about at the beginning, the Polk Brothers Foundation grew. The end result of all of this is the Polk family are still friends with each other, and the Polk Brothers Foundation is carrying on a legacy by donating money to organizations throughout the Chicagoland area, although mostly in Chicago. And there was no family issues, there were no family disputes about all of this, and that legacy continued. So I always use that as the like prime example of how being having some forethought and planning ahead can create a situation in which you really can plan for these things and enhance your business's legacy rather than take away from it.
Well, thank you. Harold, we've heard some about like squeeze outs and majority control. How does majority control arise in a company? And how can that actually become oppression?
Well, it often arises at the very beginning because one of the parties has significantly more leverage than the other, either through financial contribution or knowledge/customer relationships that gives that one person more power to exert influence over the others. That's where it usually starts. And then they use the corporate documents as a way to basically freeze out minority shareholders by giving them very few rights in the process. One example is board members. Majority might be able to remove a board member and put someone in to that person's liking, or not replace a board member after a board member leaves, and letting kind of, okay, now it used to be a 5-member board, it was 3-2. Now it's 3-1, so I'm not going to do anything about it. It's easier for me to run rampant right now. Not having an independent director is a very common way to the majority can oppress the minority. Not using special committees in conflict of interest situations, another critical way the majority exerts influence. And similarly, using compensation to transfer value, whether that is through increased salary, large bonuses, and basically manipulating the process to take value away from the shareholders. These are just a few examples of how majority can kind of run over the minority shareholders. They do have their rights. Minority shareholders will have rights under state law, but that, of course, takes time and money to get there.
Thank you. Megan, we're back to valuation. We're hearing about like minority, majority, oppression. We've heard about other types of potential legal claims or grievances. So the question is value the same? Is it always the same value per share or per members' interest unit? Does it make a difference if they're majority or minority? Does it make a difference if it's an oppression claim? Like, is value just the same in all situations?
Now, all of those things very much play into what the ultimate determination of the individual's ownership value is. And the most common standard of value that we work with and what is used for like the IRS purposes, for example, is fair market value. And that is a value considering a hypothetical willing investor purchases the business from a hypothetical willing seller. So that is often not the case, truly in how these small, closely held businesses are operating. But in an oppression situation, that hypothetical goes out the window and you're thrown into a fair value standard, which is different because it's really saying it is the oppressed shareholders' proportionate share of the whole value of the company. And it is meant to, as it says, be fair to that person to replace exactly what they would have been receiving the benefits of if they continued to stay in their ownership position. Fair market value, though, considers discounts like that minority shareholder doesn't have the control position and can't make the decisions. And, if the majority shareholder decides to lease a building from a business that they own, let's say, and they're paying in excess of fair market rent, Well, that's more money in their pocket. It's a way of diverting that compensation in a way what would have been available for distributions to all of the shareholders, but a minority shareholder doesn't necessarily have any recourse in the regular operations of the business. So if an oppression claim is made, it is ultimately a legal finding. So a valuation professional really should still consider if any of the discounts would be applicable and what they might be if they were to be applicable. But chances are, if the oppression claim holds up, it will be a fair value standard that does not consider discounts.
So Megan, if I may ask you a hypothetical, if hypothetically I and some of my friends formed a business and I invested 100,000 and some of them invested more, one of them invested say $1 million, but we all paid the same price per share at the investment outset 20 years ago. And now one of us wants out and we're a minority owner. Do we get the same amount per share as the proportion of the overall company? Because that's how we bought in, or is the answer to that going to be it depends today?
Well, if the company has grown, then the share value, unless something has happened with the distribution of the shares and dilution and things like that, the share value should have grown substantially over the course of 20 years.
So when I bought in, I didn't buy at any discounted price. You mentioned discounts. There was no discount for lack of control or minority position. Today, if I'm a minority shareholder, is that going to be the same situation?
Well, no. I mean, the position that you're trying to sell to an outside investor, let's say, is not worth as much as you having some, connection to the operations in which you were a co-founder and would supposedly or theoretically, I guess, have some say in the direction of the business and things like that. So they're, depending on what the agreements all say, of course, again, their ability to have any impact on what they can receive from the business in the form of distributions could make that really not nearly as valuable as it was even when you went into it, because say the majority shareholder isn't distributing enough to pay the tax that is going to become due as a result of the net income of the company, being in a pass-through entity, then that, the share value is actually potentially zero.
So you'd mentioned about some distinctions between fair market value and fair value. So in a fair value situation, is that a situation where maybe there'd be no shareholder level discount, even if I'm a minority owner?
That's right. And that is how they try to make it fair by, even if all of these provisions exist, which would make the transfer difficult or the minority position unpleasant or undesirable, then in an oppression situation, if the fair value standard does apply, it means that there aren't any discounts to account for those things.
Well, thank you. Max, what are the classic factors that describe oppression?
So the most basic definition is going to be where the majority is acting in a manner that is unfair to a minority shareholder, which should be determined in part by looking at what the minority shareholders' rights are and determining if the majority is observing and respecting those rights or running roughshod over them. Where you get into lots and lots of gray areas is what exactly are minority shareholder rights, because while there may be one set of definitions under certain state laws or under certain default provisions in a company's operating agreement, the parties can agree on differing rights for minority and majority shareholders. And so a lot of this is going to end up coming down to what do your documents say about what are the rights of the majority shareholders and what are the rights of the minority shareholders. some of the things that you're going to be looking for to determine if oppression is going on are some of those things that Harold was mentioning earlier. Squeezing out, excluding the minority shareholder from distributions of profits, like Megan was talking about, preventing or not distributing in a pass-through entity, not making distributions sufficient to cover the tax liabilities. You can also see, as Harold mentioned earlier, ways in which the majority run the business in a way that denies value to shareholders, but provides value to select few in the operation of the business. So if you have a majority shareholder who gets a new car every 6 months and gets to keep the old car, or those kinds of sort of um, over the top benefits, those might end up being viewed as shareholder oppression, because what the net effect of that is it takes value out of the company as an expense, but gives it to one of the shareholders in the company. And the net result is that that person is enriched in a way that others aren't enriched. You might also see things like the things that Harold was talking about earlier, removal of board members, preventing board members from having the necessary information to do their job. All of these kinds of things can be indicators of shareholder oppression. And oftentimes, when you see those, you end up in the fight. And one of the problems with those fights is a lot of this can be in the eye of the beholder, and you can't know ahead of time who your beholder is going to be.
Well, Harold, we talked a little earlier about arbitration. So what do you find is the most effective way that disputes get resolved? Is it arbitration? Is it mediation? Is it agreed negotiation? Is it litigation? What's been your experience?
Well, hopefully not litigation, because that's generally nobody wins if it has to go to litigation. So ideally, there is some sort of negotiated solution, whether it's through a mediator, a neutral lawyer, or otherwise. One way we often do it is to put the business up for sale and have an independent buyer, hopefully an investment banker who the parties can agree on, market the business to see what an independent third party would pay for it and sell the business. And that way you're limiting the fight to dollars, right? And if you don't want to sell the business, you can have a third party valuation come in and look at what the business is worth today and maybe negotiate a settlement based on that valuation. And then, as you mentioned, doing some sort of pre-mediation or a neutral lawyer who kind of can give you, looks at both sides and looks at all the documents and can give you kind of a neutral view on where that person thinks this is going to come out. Of course, that's not binding, but unless there's kind of pure hate involved, which unfortunately we do see, it can bring parties in dispute together by having this kind of middle person taking a look at what's going on.
Well, thank you.
I would add to that in my experience, the best solutions are often a combination of the things that Harold just mentioned. One of the things that I've seen actually be effective is a provision in an operating agreement that says that if the parties can't agree on the value of the company, then the company will be put up for sale. But any member of the company has the right to beat a sale price. And in those circumstances, that is the one set of circumstances where I have seen parties who can barely be in the same room with each other actually come to an agreement as to the value of the company, and actually come to an agreement in which that value is preserved, and they get to split that value in the way that they have previously agreed it's going to be split. And it's all because there's enough sort of circuit breakers there that require reasonableness, that the parties actually have to act reasonably as they go through the emotional roller coaster of their dispute. At the end of the day, they have a business, it has some value, and they know that if they figure out how to agree on that value, they will get to share in it and see it actually realized, as opposed to what often happens if it does, as Harold said, heaven forbid, end up in litigation, which candidly is what I do, but it's still heaven forbid if it ends up there, because then what you see is the parties effectively engaging in scorched earth litigation. And at the end of it, you rarely have a business that's worth anything near what it would have been if they'd reached an agreement on the front end.
That's interesting, Max. Can I just ask, when you have a right of first refusal provision like that, does it actually depress the value that is being attracted in the market for the business, though?
Well, so it can depress that, because the market might assume that one of them is going to be beat your bid. But the way it's actually, I didn't fully describe it entirely accurately. The best way to do it is that you have you hire somebody to sell the business. Each of the parties and any other third party can engage in the negotiation to buy the business. And what that then does is it requires the parties inside the business to be reasonable, because they know if they try to lowball it, their opposition on the other side of the business is just going to beat them. And so they get to a place where they say, oh, this is actually a fair value. The other side says, well, I'd rather just take the money, or says, I see how they got there, but I think I can do better, so I'm going to bid, $100,000 more, or whatever it is. And at the end of the day, you end up with a pretty reasonable and pretty fair valuation for the company. And everybody knows from the get-go that they're either going to get the money or the business. And either way, they want to make sure that the business still has value.
Right. And to Megan's point, right, that's why you sometimes go with a valuation firm as opposed to exposing it to the market, because you could get the same results Max just talked about without having the depressive market value that Megan alluded to.
For sure.
Well, thank you. So Megan, since we have transitioned into the valuation realm, and you are a business valuation specialist, what is an independent appraisal of value? And what does it mean to be a business valuation expert? How do you tell?
Well, an independent appraiser is somebody that doesn't have a vested interest in the outcome. So that's just somebody that's going to be having a neutral opinion, essentially, as to the value of the business. And as far as the experience of an expert in the field, there are various credentials. I think there's about 4 active organizations that issue standards, and the practitioners have to comply with the standards, and it does require a certain level of education and experience before you can hold the designation. So that's kind of like the basic bar for whether you can be a practitioner in the field. In a context of litigation, I would say to be an expert and to be a valuation analyst that also testifies and is involved in this kind of, a little bit more difficult day-to-day operation of a valuation analysis, let's say, because in an appraisal for fair value purposes for financial reporting, you're going to be dealing with a company that's very open with their books, interested in cooperating with you. All your questions can be answered. In the litigation context, especially in a business divorce scenario where you've got very contentious relationships between these parties, and you may be operating on behalf of the minority shareholder, you might not have all the information that you'd like to have. So there's, I think, a little bit more that is involved with being a testifying expert than there may be with some other forms of valuation. There's a lot of other reasons to do valuation. So there's valuation professionals that do all manner of things, but the experience certainly does depend on the scenario you're going to use them for.
So, Megan, if you are retained as an independent business appraiser, what are some key questions you would be asking of counsel and the client? Like, how would you know what your scope is?
Well, it's going to be standard of value, like I talked about. That's a big one. valuation discounts are a big component of the ultimate answer when it comes down to the number. The valuation date, was there something that occurred that you have to move back the date to measure the value of the company at some prior point in time? You're going to want to obviously get a hold of all of those provisions in the operating agreements. And, it's possible that you could have as a starting point some calculation that is existing within the buy-sell agreement that might make the task simplified for everybody. Or you might have a lot of question marks about how many methods do we have to apply, and are discounts going to be applicable? So there's a variety of factors that usually I send out about a 10 to 12 page information request as soon as a valuation engagement begins, because that really helps hone the scope and what level of work is actually going to be required to get to the right answer.
So you mentioned methods. Is there more than one method to valuing a business, and might it make a difference if it's an operating business or an asset holding company?
Yeah, absolutely. There are 3 standard approaches to value, and within the approaches, there are some different methods. So the asset approach is used for a holding company because, generally speaking, there isn't intangible value that isn't already recorded on the balance sheet. So an asset approach just takes all of the assets that the company holds and records them at market value, and that gives you your current market value of the company. That wouldn't be an applicable really way to value an operating company that does have goodwill, because unless some transaction has taken place and that company bought out another company and because of that reason has some goodwill on their balance sheet, that's not going to be captured with the asset approach. So then you go to either a market approach or an income approach, each of which have a couple of different methods that can be used. And that really is going to depend largely on the availability of data for the particular engagement. Most times, if you're dealing with a very small, closely held company, a guideline public company method under the market approach is not going to be very applicable, because public companies operate very differently than small privately held ones in most cases. And there's a big size variation as well. So then instead you look to transactions in the marketplace that other companies that might be similar that have sold. And the income approach is simply looking at all of the future benefits that you expect to get from the business and presenting them in today's dollar terms.
And so what are the key valuation drivers in most businesses?
Well, growth assumptions for sure, and profitability are the big drivers that put cash in the pockets of the owners. And so those are the big ones that can move the needle, so to speak, when it's an income approach is being used. Also, that impacts the market approach because the transactions that have taken place involves different growth assumptions.
What about financial leverage? Is that a common factor in valuing a business that may be failing?
Well, certainly if it's failing, if they are not having very positive access to credit, or if they're paying high interest rates, that's going to depress the value of the company to the current shareholders. But if you're looking at the enterprise value and thinking of it from a hypothetical buyer perspective, then you don't have to necessarily consider these, disadvantageous interest rates that they might be paying, or if they're over leveraged, they might have other scenarios that the bank is requiring them to comply with. It's taking up a lot more of the time and resources of the company, where they could be focused on more productive efforts.
right? Or stated perhaps slightly differently or in addition, you're probably looking at an asset sale versus a company-wide sale in which the leverage wouldn't be as important because people aren't buying based on a revenue stream, right? They're buying on the value of those assets. And therefore, you may have a different value. It may not be as much, but as Megan said, from a shareholder's perspective, that's not going to be very advantageous. But from a corporate paying off debt, then the amount of leverage kind of is what it is. The assets sell and the proceeds just go down the line according to priority.
Mhm.
Well, thank you. Max, is there more than one role that a valuation expert could play? Are they always just the independent expert for the company, or do they possibly play some other roles?
Oh no, they actually could play a variety of roles. And actually, one of the things that I would advise anybody who is getting into or fears they may be headed towards a business divorce and a valuation dispute is to engage somebody at the very earliest opportunity to give you a sense of what your business is likely to actually be valued at. Because the worst thing you can do is pursue a fight over the value of a business and a year or a year and a half in find out that you're fighting over a business that is worth far less than you thought it was worth. And so one of the things that I think is critical is for a lawyer like me to partner with a valuation expert like Megan at the front end so that my client and her client has a clear understanding of what the value of this business is, because candidly, that's the value of the fight. And you should know at the front end whether the fight is worth engaging in. And if you don't know that at the front end, then, and instead you're just going on what you hope is the right answer, you're effectively going into that fight blind. You might end up wasting years of your life, hundreds of thousands of dollars, if not more, fighting over something that at the end of the day isn't worth what you thought it was worth. Now, that isn't to say that valuation experts don't also have value as the independent experts who aren't necessarily providing that kind of guidance. Like there's a combination of roles that can be played there, and it will, what the right role will be depends on the valuation expert and depends on the documents that define the fight and define their role. So there may very well be a valuation expert who is an excellent advocate for the valuation that they're able to support. That same valuation expert who would be great as an expert witness in a business divorce litigation or arbitration might not be the best valuation expert if you are submitting everything to a third party for just a arbitration style, baseball arbitration style determination. So these kinds of things are factors that should be considered when considering who you want to hire as your valuation expert. You should think about what role they're going to play, how they're going to play that role, and how you want them to be helping you advance your case.
Well, thank you, Max. As we come down to the final few minutes here of our program, Harold, I understand you have a recent real-world case example that our audience would probably find of interest that exemplifies some of what we're talking about today. Would you like to share that?
Sure. Well, in the short time we have left, it's a Sonder bankruptcy case. It's a bankruptcy. The company was started in 2012, kind of as an Airbnb competitor, different type of model, where Sonder actually owned the buildings and leased them kind of like on an Airbnb type basis instead of a hotel. They started with, by a student in out of their dorm room, grew to 9,000 units in 40 cities, but had tremendously high costs because unlike Airbnb, they had to pay for the furniture, they had to pay the taxes, they had to pay the upkeep. The idea was that it'd be a technology driven, so there'd be no receptionists, right? Everything's done via an app. and they ran into some trouble. They entered into a licensing agreement with Marriott in June of 2025 to try to augment their revenues. Unfortunately, the implementation was, to put it mildly, a disaster, and they had to file for bankruptcy on no notice, leaving guests unable to access their rooms or finding their possessions in a hallway. And there ended up being a very, very small recovery for the people that lent them money, and nothing for the equity. It was one of those things that was a good idea, but when compared to Airbnb, Sonder had long-term leases, Airbnb had nothing. Sonder had high costs for units, Airbnb had nothing. Operating risk was with Sonder, Airbnb, it's with the hosts, and scalability. Anyone could run an Airbnb. It was very costly for Sonder. So it was a business model that started out good. They grew too fast and did not know how to manage their growth, and ended up as unfortunately a disaster for everybody.
Well, Harold, thank you. On behalf of Financial Poise, all of our speakers, Megan, Harold, and Max, we thank you very much. Our audience, we encourage you, if you have questions, whether you're watching this live today on January 29th, 2026, or you are watching it on demand later in the year, all of our speakers and panelists' email information is in with their bios in a slide deck. They welcome you to reach out to them. And on behalf of Financial Poise, we thank the most important people in this program, our audience, for joining us, and we look forward to seeing you on future Financial Poise programs. This concludes our webcast, and we look forward to seeing you another day. Thank you.
Thanks, everybody.
Thank you.
Bye-bye.